A process server knocks on Marcus's door. Same week, one knocks on Diana's. Both get the same $11,000 lawsuit. They're both wrong about what just happened, but only one is wrong in the way that costs $14,200. Marcus throws the papers in a drawer. Diana files one document. 5 weeks later, case dismissed for Diana. Garnishment in the mail for Marcus. Both had 30 days. Only one used them. I'm Riley, and on this channel, we break down the personal finance moments nobody warns you about. The ones where doing nothing costs more than doing the wrong thing. Today, the 30-day window. The one most people sleep through. And the one document that costs $50 and a single afternoon to file. If you've ever stuffed an envelope into a drawer because you didn't want to know what it said, this video is for you. By the end, you'll know exactly what to do in the first 30 days after a process server hands you papers. Even if it's not happening to you right now, especially if it's not happening to you right now. Here's the statistic that makes debt collectors very, very happy. According to a Pew Charitable Trust's study of state court records, roughly 7 in every 10 debt collection lawsuits end in a default judgment. That means the person being sued never showed up to court, never filed a single piece of paper, never said the word no to a judge. So the judge says yes. The judge has to. Default judgment means the plaintiff gets everything they asked for. The full amount alleged, court costs, interest going forward, sometimes for years, permission to garnish wages, freeze bank accounts, and put liens on property, all of it, automatic. That's why the entire junk debt buyer industry exists. A junk debt buyer is a company that buys old, defaulted debt in massive portfolios for pennies on the dollar. We're talking 3 to 5 cents per dollar of debt face value. So Carl's company buys a portfolio of 10,000 credit card accounts for a few $100,000. Most of those accounts they will never collect on. They don't need to. They only need a small percentage to pay. And the math works. How do they get people to pay? They file lawsuits, thousands of them, sometimes tens of thousands per year per company. And they're betting on one number, 7 out of 10. If 7 out of 10 people they sue never respond, they win those cases automatically. No proof required. No documents shown. No witness testimony. Just a clerk's stamp and a judgment for the full amount. Here's the part of the industry that does the heavy lifting. When a debt is sold 3 or 4 times, the paperwork rarely follows. The original creditor, the bank or credit card issuer, has the contract you signed. The first debt buyer might have an assignment letter. By the time it reaches Carl's company on the 4th sale, what they actually own is a row in a spreadsheet. Your name, a number, a balance. If you challenge them in court and demand they prove they own the debt, demand they show a chain of assignment from the original creditor to them, they often cannot do it. And under the Fair Debt Collection Practices Act and basic court procedure, if they cannot prove standing, they have no right to a judgment against you. The case gets dismissed, but you have to ask, you have to show up. Before we get to what Diana actually did, here's what you should absolutely not do. Do not call the plaintiff's attorney to work something out. Anything you say on that call becomes evidence the debt is yours. You just took the burden of proof off them and onto you. Do not negotiate verbally or offer to settle for less. Even a small payment restarts the statute of limitations and confirms the debt. Do not throw the papers away. Do not ignore them hoping it goes away. Lawsuits do not expire on their own. The clock is running whether you open the envelope or not. 3 rules. Then we move to the actual move. Marcus opens the door. Process server hands him the papers. Marcus closes the door, looks at the cover page, sees the word court and a dollar amount, and feels his stomach drop. He puts the papers in a kitchen drawer. Day 5, he tells himself he'll deal with it next weekend. Day 12, he tells himself he'll call someone. Day 20, he tells himself maybe it'll go away. Day 31, he tells himself nothing because the deadline already passed. 3 weeks later, his employer gets a wage garnishment order. 25% of every paycheck gone until the $14,200 judgment is paid in full. His boss sees the paperwork. His coworkers do the math. Marcus did not lose the case in court. He lost it in his kitchen drawer. Diana opens the door. Process server hands her the papers. Diana sits down at her kitchen table and reads them. She finds the deadline. In most states, it's 20 to 30 days from the date she was served. She writes that date on her calendar in red marker. That is her drop-dead deadline to file something called an answer. An answer is not a courtroom argument. It is not a defense you have to win on day one. It is a piece of paper that tells the court, in writing, that you dispute the claim and intend to fight. In her answer, Diana does 3 things. 1. She denies the allegations generally. She does not have to prove anything yet. She just has to say, in writing, that she does not agree with what the plaintiff claims. 2. She demands the plaintiff prove standing. She asks the court to require Carl's company to produce a chain of assignment from the original creditor. If they cannot, they have no right to be in court at all. 3. She asserts affirmative defenses, statute of limitations on the alleged debt, lack of standing, failure to validate the debt under the Federal Fair Debt Collection Practices Act. She files the answer with the court clerk and mails a copy to the plaintiff's attorney with a certificate of service, total cost, a $50 filing fee, and 1 afternoon. 5 weeks later, Carl's attorney cannot produce the chain of title. The judge dismisses the case with prejudice. That phrase, with prejudice, means Carl's company can never refile the same lawsuit. It is dead. Diana's debt is gone. If a process server hands you papers, here is what you do. Day 1. Read every page, find the deadline. Write it on the calendar in red. Do not panic. Do not call the plaintiff's attorney. Do not call the number on the lawsuit. The clock has started, but you have time. Days 1 through 7. Gather everything, old statements, letters, the original credit card or loan agreement if you can find it, anything that shows when the debt was last paid, when the account was opened, and who the original creditor was. Days 7 through 14. Write your answer. We have a free state-by-state answer template generator at debtdefensekit.co. It walks you through the exact language for your state. You fill in the blanks. It produces a court-ready document, days 14 through 29. File the answer with the court clerk in person or by e-filing where available. Pay the filing fee, usually $30 to $75. Mail a copy to the plaintiff's attorney with a certificate of service. Keep every receipt. Day 30. Done. You're in the fight, and you've already beaten the 7 in 10. Now what if the deadline already passed? Day 31, day 60, day 6 months out. Maybe you've already gotten a garnishment notice. Maybe Marcus is you, and you're sitting at the kitchen table right now wondering what to do. Here's what most people don't know. Under Rule 60B of the Federal Rules of Civil Procedure and similar rules in every state, you can file a motion to vacate the default judgment. The standard is excusable neglect. You show you didn't get notice or you had a real reason. Health emergency, mail stolen, served the wrong person at your address. Most states give you up to 1 year from the judgment date. It's harder than answering on day 20. The court is reluctant to undo a judgment once it's entered. But it's not impossible. Day 31 is not game over. Most debt collection lawsuits are not won by lawyers in courtrooms. They are decided by whether the person being sued opens the envelope and takes 30 days seriously. If you opened it, you already did the hard part. The free answer template generator is in the description. The full debt defense kit includes answer templates for all 50 states, the discovery motions that force Carl's company to produce documents they don't have, and the step-by-step playbook for the entire dismissal process. Once the suit is dead and your paycheck is yours again, the real work starts. The work where you stop defending money and start building it. Your first $1,000 emergency fund. The one that means no process server ever scares you again. I'll see you in the next one.